fights with passion, and he inspires.
Are you ready for a war?
All right, welcome back. Welcome back to From A to Arbitration. I hope everybody had a great week. I wish y'all could hear me cussing myself. This is about the 10th time I've started this episode. And my nose is running. I can't quit yawning. I'm just mad, just cussing myself. I shouldn't cut those out. I should let y'all hear that because it's me just cussing my ass out. Like, I'll be yawning like, motherfucker, quit yawning. Anyway, and my nose just started running out of nowhere. And so now I'm blowing my nose like crazy. I've started this thing like 10 times. And so we're going to get through it, though. I promised you I'm going to get through this thing. Next Sunday, I'm going to cover a few things. I'm going to tell you what I'm going to cover. Failure management allows us to interview supervisors. We're going to cover that because that's happening a lot right now and will continue to happen. The more educated we get, right? The more educated we get, specifically when we talk about concurrence issues. This is why I'm doing this, because a lot of people said when they messaged me about concurrence, I say interview the concurring official. You can't do that. We're not letting you do that. So we're going to cover that. I think I did an episode on that before. A lot of people are being disciplined right now for failure to meet standard. And I'm going to go over that next week. Got some arbitration sites. Also, personal items at our case. That was on social media last week. A lot of people, and that's one of the great things about social media, about Facebook, and I know that I bitch about the NBA's not doing shit, relying on Facebook. A lot of educated people on Facebook. So when they put something up, usually within a few comments, it's handled. Okay, it's handled. So, but I'll cover that. Personal items at our case, okay? So next week, failure to allow interview with a supervisor, discipline for failure to meet standard, and also personal items at our case, okay? So we'll do that next week. I got a couple of things I'm going to go over, and then the two things that I'm going to address are very brief, okay? Talking about the counterfeit postage, and the reason that's important to me is if we're going to continue to say that we're broke, when the CLC gets in there, I'm going to say there's a great chance of a forensics audit on the books, because I always say you need to get in those books. And so, but you have losses in grievance settlements. You also have loss in counterfeit labels. So to me, if you're going to continue to say that we're losing billions, quit giving me packages with counterfeit labels. We need to be collecting on everything, right? I'm going to cover that. It's going to be very brief, like I said. And then also this medical documentation. It'll be very brief as well, but it's going on like crazy. So I'm going to touch on a few things that I was talking about. If y'all didn't know, I did some episodes last Monday and Tuesday. Went off a little bit, but one of the things was St. Louis. And it's completely bizarre what's happening to those carriers in St. Louis, Missouri. I told y'all that they came in and they took the senior carriers routes out after a 6-day count. Now the LMOU, they sent me the LMOU and it talks about kind of implying junior carrier. It says junior carrier. And the reason they do that is because they don't want to negatively affect the entire installation. If you take out the senior carrier's routes, everybody's route underneath them goes up for bid, right? And so the shop steward is imploring the postmaster who came in here with a vendetta. Okay, matter of fact, this shop steward's gone to the news media and everything, calling this postmaster out by name. Because what the postmaster has done is fucked over the entire city of St. Louis. I'm talking about customers and everything, because 1,100 routes went up for bid based off of this fool's directive. Okay, one of the problems that they have, and they'll win the grievance, but like we talked about, the grievance procedure is that you're going to wait 8, 9, 10 months because of the complete fucking failure our union is right now at getting those cases heard. One of the problems is that there was no mail. A few of the days, and this is in an OIG report, matter of fact, there was no DPS on the 6-day count. They come in, no DPS. They counted those days anyway. You're going to lose that. But do they care? No. They wanted to fuck with the city letter carrier. Another thing that he told me is that if you don't put the routes up timely, you have all these routes go up for bid, you don't put them up timely in their installation, it's $800 per carrier per grievance because they fail to do it so many times. And you look at, and I'm going to go off again. You talk about weaponizing a cease and desist, okay? You talk about weaponizing a cease and desist, and that's what management has, made us buy into that shit with Barner and Renfro and now the director of retirees going around. You got business agents talking about cease and desist, no longer do cease and desist. Here's one of the problems with that, okay? Here you have this installation. They've done it so many times, it's become so egregious that they're up to $800 a carrier or $800 a grievance if you don't put a route up timely, okay? Well, they didn't put these 1,100 routes up timely. So he's asking for $900 per grievance. That's 1,100 grievances. That's 1,100 grievances at $900 a pop. Based off of something where the postmaster has come in and said, we're going to fuck y'all over intentionally. And somehow you will find that the Postal Service will fault us for it because we weaponized the cease and desist. It will become our fault. You'll probably hear something from Barner about don't do that because we're weaponizing the cease and desist. They can intentionally fuck us over time and time and time again, and at the end of the day, somehow miraculously, it's our fault. Do y'all understand that? It's our fault. Y'all weaponizing the cease and desist. Our own people coming in, no longer asking for cease and desist, you're weaponizing that. Matter of fact, somebody sent me a screenshot of something that they had in their installation, and I'll read it. Labor is saying our postmaster can't sign a management shall stop violating. They say it's the same as a cease and desist. That was sent to me. Now labor is saying our postmaster can't sign a management shall stop violating. They say it's the same as cease and desist. So that's what we're up against. Here you have an installation that's gotten up to $800 a violation because management can't do the right fucking thing. So he's asking for $900 per grievance. You got 1,100 grievances coming. He tells them, look, put it back like it was. Take out the data because we didn't have any mail. You didn't have any DPS during that time. Take all that out. I won't file these grievances. I won't file a grievance if you do that. They told him to go fuck himself. They're taking them out anyway. Let me ask you this. We have Barner, okay, Pony Boy. Management calls him at the national level, and I've talked about this before. And they say, hey, there's this arbitration award out of Region 2. And we don't like the language because the arbitrator said there's been so many violations, the union shouldn't be here. There's been so many violations, the Postal Service is going to pay full freight on this arbitration. Usually it's the Postal Service and the union splitting the fee, okay? He said, the Postal Service is going to pay the full fee, pay full freight. The union's not going to be responsible for these fees because we shouldn't be here. Y'all continue to do this so many times. The union shouldn't be here. Y'all are going to pay full freight on this thing. And they had some other arbitration decisions in there for persuasive value, talking about the same thing. The Postal Service doesn't like it. They don't like it. So they go to Barner, your executive vice president, and they talk him in to making a joint phone call to this arbitrator to tell him he can't do that, even though there's other arbitration sites in there for persuasive value where they did it before. And they convince Barner to do that. And he does it, your EVP. He doesn't tell them, hey, look, if you don't like it, go to court and vacate it, which is what I'm going to do. I will never call and have an arbitrator amend a decision on management's behalf. I will tell them, take it to court and vacate it if you don't like it, because the arbitrator is correct. That's the reason in the grievance when we put remedy requested, we put or whatever the arbitrator deems appropriate. So this arbitrator deemed it appropriate that management pay full freight. And your EVP, Barner, Ponyboy, calls the arbitrator with management and tells him, amend it, you can't do that. Okay? Also, Barner, when you have this Memphis decision, arbitrator Swallow, you'll remember he was on my podcast. They don't like that decision, don't like Swallow. So what do? They convince Barner, your EVP, to call and kick him off the panel mid-panel. They're still on these panels. They kicked him off 2 years ago. They convinced Barner to do that, right? They also convinced Barner, your EVP, to go in amongst these DRT teams and tell them no more cease and desist. Matter of fact, Lloyd's raising his voice at the DRT teams. First off, if I'm in there, I'm going to say, hold up just a second. Hold up. I didn't know he was going to do that. I'm going to have my people step out. You can yell at your people. You will never yell at mine. Ever. I'm not going to raise my voice to my people. You damn sure ain't going to do it. We're all going to talk like we're civilized human beings in these meetings. If you can't do that, we just won't come to the fucking meeting. You can yell at yourself. But anyway, raises his voice at the DRT, telling them that we weaponized the cease and desist, and Barner goes along with that. That's your EVP. Why is it? Why is it when you see something happening like this that's devastating to the city letter carrier craft, why can Barner not reach out to somebody and say, hey, look, remember all these favors I did y'all? I need one. You got complete fuckery going on in St. Louis. Complete dumb fuckery going on in St. Louis. I need you to make a phone call and tell that postmaster, quit fucking up shit. Put the routes back like they were and do a right 6-day count. They're bringing the same team in, the same incompetent fools that did it. They're bringing them back to do it again. And they say these motherfuckers are just arrogant, pompous asses. So St. Louis, Missouri has been abandoned by both parties. Like I say, we have as a light blue as the craft. And that's what's going on with your brothers and sisters in St. Louis. 1,100 routes up for bid. They didn't put them up timely. $900 per grievance. It's over $2 million. And I'm going to tell you this, after all of it's said and done, it'll probably be up to about $4 million. All the issues they're fixing to have, overtime and all these things, based off of this one postmaster. Right? Based off of this one postmaster. Y'all remember I told you back when I was talking about ergonomics, and we had the district manager come in and was just doing stupid shit. Put all of our mail on the ground, took our tubs away, and put our mail on the ground. I came back one day and I was like, what in the fuck is the mail doing on the ground? Well, the district manager there's this new AMSOP, and he wants the mail on the ground. Why? He said it makes it look cleaner back here, for the public. Nobody comes back here except for the city letter carrier. We're not putting the mail on the fucking ground. We're not going to have it. That's idiotic. And so I had to grieve it. And then the district manager came out, wanted me to take away the grievance. He said, we withdraw the grievance. I'm not withdrawing the grievance. I said, go put your shit on the ground. Go to your office, take out your desk, put all your shit on the ground. That's what I told him. All the carriers are listening. I said, put your shit on the ground. And work like that. Phone, computer, laptop, take your fucking chair out, put all your shit on the ground. That's how I felt. You're not going to treat us like fucking dogs. So I go to the guy that's over, this is when I was on the National Safety Committee. So there's a meeting. I go to the guy that's over ergonomics for the country, the entire country. I go to him and say, hey man, your ergonomic shit y'all been preaching? Yeah. They're telling us to put our mail on the ground in Nashville. What? What are they doing that for? Some kind of AMSOP. That's ridiculous. I know it. I said, hey, why don't you call the district manager? Oh, I can't call the district manager. Well, why not? You're over ergonomics. No, I can't do that. Well, give me a statement. I can put it in the grievance. No. But tell me how the grievance goes. Honest to God, that was the conversation. I said, give me a statement. I'll put it in a No, I can't do that. I said, what good are you? That's when, you remember that business agent came in, put his arm around me. Then I went to the head of safety. I think her name was Linda DiCarlo. She used to work for headquarters and swapped over to management. I think that was her name, Linda DiCarlo. Told her about it. What are they doing that for? Fuck if I know. Some kind of AMSOP. Is there any way you can call the district manager? I can't call the district manager. Can't do that. What good are you? It's always funny when we need help from them, right? About some stupid shit their people are doing, they're non-existent. When them motherfuckers need help from us, what they do? Call Barner. Motherfuckers there on his hands and knees, crawling up to them motherfuckers trying to help. Why is somebody not helping St. Louis, Missouri? Why is no one at headquarters and national going to St. Louis and telling that postmaster, hey, quit being a dumb fuck. Put the routes back like they were. You're fixing to cost us $4 million, already at $2 million. The shop stewards begged them, don't do it. I'll withdraw all these grievances. Just put the routes back like they were. No, we're not going to do that. So that's what's going on with your brothers and sisters in St. Louis, Missouri. Okay? Y'all remember to say a prayer for them as they go through this shit. Say a prayer for your people in St. Louis, Missouri, your brothers and sisters. National should be in a fucking uproar, but hell, Renfro can't stay off these fucking Zooms and pods and all that shit. Motherfucker, he's got to get it in now, though. Like I said, motherfucker's got to get it in now, because once he says he's running, he can't do that shit. But fuck it, that motherfucker's over. I'm going to play a little clip for you in a second about this motherfucker already conceding on our next contract. Got something else, a few other things, and I'm going to get into this stuff. Got this sent to me. Today, Sunday, November 9th, marks 2 months that Region 1, California, Hawaii, Nevada, and Guam, has been without a national business agent. September 9th, former NBA Keisha Lewis was installed as president of Branch 1100. Since then, President Renfro has not appointed an individual to fill such vacancy created by Miss Lewis's returning to her branch. Article 9(1)(c) of the NELC Constitution, as it pertains to the Constitution of the National Association of Letter Carriers, states, the President shall fill all vacancies occasioned by death or otherwise with person duly qualified until the next election be held. While the Constitution does not provide a time frame in which President Renfro needs to make an appointment, the vacancy created by Ms. Lewis was not unforeseen. Listed below is the timelines. As early as March 29th, the tickets, Paul Perry and Anita Price slate versus the Clear Choice slate, competing against each other in Branch 1100, had their campaign flyers posted in the Union Carrier, which is Branch 1100's April, May, and June quarterly magazine newsletter, which was printed to be mailed to the branch membership. June, nominations took place. July, elections took place. September 9th, Miss Lewis was installed by Stephanie Stewart. At least 6 months prior to Miss Lewis being installed as president of Branch 1100, the NELC was aware that there may be a potential vacancy if Miss Lewis wins. Why is it taking President Renfro this long to appoint a national business agent? He had ample time. The last time there was a Region 1 NBA vacancy was when Chris Jackson was appointed Director of City Delivery. According to the January 2017 edition of the Postal Record, President Rolando appointed Chris Jackson as Director of City Delivery effective January 2nd of 2017. On the very same day, President Rolando appointed Bryant Almario as Region 1 NBA effective January 2nd, 2017. Is President Renfro waiting to see what happens with Branch 1100's contested election results? Is he messing with the region because of the no confidence vote that took place at the California State Convention? If so, there are 2 other states, Hawaii and Nevada, and a territory, Guam, And neither of those did the same at their conventions. Is he doing this to ensure the region does not have representation in executive council meetings? There have been 3 executive council meetings so far where there has been no voice from Region 1 due to the region not having an MBA. Additionally, every region has their MBA as part of the bargaining subcommittees taken from the NELC website. Region 2 MBA is a part of Articles 5, 15, 17, and 31. Region 3 MBA is part of Articles 7, 12, and 26. Region 4 MBA is a part of Articles 10, 11, 16, and Appendix B. Region 5 MBA is a part of Articles 5, 15, 17, and 31. Region 6 MBA is part of Articles 4, 8, and 41. Region 7 MBA is a part of Articles 13, 14, and 35. Region 8 MBA is a part of Articles 5, 15, 17, and 31. Region 9 MBA is a part of Articles 10, 11, 18, and Appendix B. Region 10 MBA is a part of Articles 13, 14, and 35. Region 11 MBA is a part of Articles 7, 12, and 26. Region 12 MBA is a part of Articles 7, 12, and 26. Region 13 MBA is a part of miscellaneous issues. Region 14 MBA is a part of Articles 5, 15, 17, and 31. Region 15 MBA is a part of Articles 4, 8, and 41. Region 1 does not have a national business agent representing the membership of the region during collective bargaining. President Renfro is taking adverse action against the region, and it is hurting the membership. To recap, Region 1 has not had an MBA for 2 months as of November 9th, 2025. President Renfro had nearly 6 months at a bare minimum to prep for Ms. Lewis's departure. There have been 3 executive council meetings where Region 1 has not had a voice. Region 1 does not have a voice through its authorized agent MBA in collective bargaining. Every other MBA is on the bargaining committee. President Renfro, at the CLP, you stated you will select an MBA soon. Hell, we should have known something then. We should have known a motherfucker will wait 700 fucking days hinging on that one fucking word. President Renfro at the CLP stated you will select an MBA soon. The region hopes that your current definition of soon is not the same definition as soon that you relied upon during the last round of collective bargaining or begging, whichever you choose. And so that was sent to me by a carrier out in California. And the carriers have no representation as far as an MBA. So when you say, call the MBA, there's no one to call. They can call the MBA office and talk to an RAA or an RGA. But it's another colossal failure by this dumb fuck president because he can't get out of his own fucking way. I'll tell you what's going on. Now, this is just me. The motherfucker, his pride has crippled his ass, just like other business agents. Mine's another one. Pride has crippled their ability to function. Just like him taking Mr. Henry's responsibilities away, Mac Julian's responsibilities away, Chris Jackson's responsibilities away. He goes out to California. Unanimously, they give this motherfucker a no contest vote. Okay? And so what does he do? I'll just pay y'all back. I'll just pay y'all back for that. Y'all won't have a business agent. Only problem is Nevada's in that. They didn't have that no confidence vote. Hawaii's in that. They didn't have a no confidence vote against your sorry ass. Guam is in that. They have nothing to do with this. It's just another example of this dumb fuck's incompetence during this period of time. He's the biggest mistake we've ever made as a body, is voting this motherfucker in. We took Rolando's word that he was going to do well, and he put him on the slate. We took that for granted, and we have suffered dearly because of it. We have paid dearly because of that. And I still kick myself in my own ass all the time for doing that. I'm going to do a shout out, and then I'm going to get into a clip, and then I'll get into this grievance, okay? And I like this shout out. I like this shout out a lot. It's the only one I'll have. Hi, Corey. Can you give a shout out to all the people running on the CLC ticket? Give them hell. and an anti-shout-out to those spreading the USPS propaganda about running out of money by 2027, as we are beginning another contract negotiations after they just gave performance bonuses to all of management. And I saw that. I saw those performance bonuses. I don't know if y'all saw that, but it didn't keep them from getting those performance bonuses, which are astronomical. So absolutely, I'll give you a shout out. Anytime you're going to shout out the CLC, baby, I'm going to get that one, okay? So I've got this clip I want to play you, and it's been going around, and it's basically our president conceding already that we're not going to do well, okay? And I'll tell you why I had the problem with it, but
I think it's fair to say and expect that the opportunity for us through the type of bargaining relationships we've had for a long time, bargaining in good faith on both sides, to reach an agreement that's fair to letter carriers and to send out for ratification is probably not great, to be very honest about it, next year.
So there you have it. There's a clip. They had him on Next Generation Carriers podcast. And he gets on. Then he goes on to state, they're going to have to do something like get the public involved. So I'm glad they've been listening, because we've been saying that shit for how long? Get the public involved. You got to get the public involved. Now your president's saying we need to get the public involved. These motherfuckers are a day late, $1 short on everything. It seems like everything that we say on here, a few months later, they'll start doing it. Have you ever noticed that? When we talk about grievance starters on here, we'll put them out, and a couple months later, they'll come out with them. We'll talk about issues on here. A couple months later, they come out with them. What are y'all doing? And then you got this dumb fuck again talking about it's just not looking good for us. And that's fine. But to me, you don't do that. Just like when you don't come out and you say, they're broke. I've done everything that I can. I've done everything that I can do. And I've squeezed every penny that I could out of them. And it's just everything that we can get. You don't do that because you've yet to go to arbitration. So you don't come out and say, hey, I just met with them for 700 days. They're broke. There's nothing we can do. I can't get any more. He's already conceding before we go into contract negotiations. Here's my problem with Renfro. And this is, it is his fault. It is his fault. But the problem is that he may be telling us the truth about things when they come up. I don't trust him. I will never trust him again, because he has lied to us too many times. Not that he's just lied. He's never apologized for lying. And I know this dumbass was on social media the other day trying to defend him, saying those were goals of his. They're not goals. He lied to us. So therefore, I cannot trust him. I don't trust him not to go into arbitration, just like he did last time, undercut us, just so that he can say, I told you so. I told you so. See, went to arbitration, put our case forward at 1.3%. Told you so. Told all these naysayers. I told y'all. Told you so. See, and that's not fair to him, because he may legitimately go in there and do all he can. But I don't trust him any longer. It's just like management when they fire us because we falsified something. Well, they say, you've broken the bond of trust between us. And arbitrators will agree. I know you got a bank of goodwill, but when you falsify those clock rings or the scanner data, when you falsify, you've broken the bond of trust. He has broken the bond of trust between us and him. Light blue and him. He's broken that bond of trust, and it will never be regained. And that's unfortunate that that's how we are with our leader, our president, is that he's broken that bond so much so, I don't believe anything he says now. But he's on record saying, the likelihood of getting something good for the carriers is slim. Here's what I want you to do. For me, as a city letter carrier, Quit making fucking excuses. Get your fucking shit together and go into arbitration and fucking fight. Quit coming out here with fucking excuses because you're sorry as fuck. I don't want to hear it anymore. Take your funky ass into arbitration and you fight for us. And wear your stupid ass red shirt while you're doing it. Fight like hell. Wear that to arbitration. So that somebody in there will know somebody's fighting for us. Quit making fucking excuses. Go fight. That's all I want. I don't care about shit else. I don't care about nothing else. Go fucking fight. That's what arbitration is for. Okay? That's why I love what James Henry said. 150 days, we're getting a date. That's what you got. 150 days, we're getting a date. That's how I feel. You're mandated 150 days. All right, let's talk, do what we got to do. 150 days, on day 151, get a date. Arbitrator, get a date. We're going to arbitration. 700 days, inexcusable. Should have got fired then. Should have resigned. Should have stepped down. To me. That's what he should have done. But, the incompetence, I'm so sick of it. I'm so sick of the fucking incompetence coming from our union. Just like St. Louis. Why are we not down there raising fucking hell? Why are we not down there in force? Can anybody tell me? Here's just some shit I took off of social media. Just this week. Okay? Some screenshots of things. And this is why I say I'm tired of the incompetence. Here's a scatter message. Carriers, we are not sitting on the clock. Any stationary time will be taken back. I'm going to read that again. This is last week. Carriers, we are not sitting on the clock. Any stationary time will be taken back. So they're not going to go out there on the street like they should. They're not going to go out there in accordance with 134 of the M39 and look at us and see what we're doing. They're just going to go by this scanner and say, any stationary time, we're taking it from you. How many of y'all are going to look at your checks to see if they've taken time from you? How many of y'all do that? But we're going to have to start doing that, right? Because they're going to steal from us. That's who we work for. We work for thieves. We work for thieves. They're the most dishonest human beings I've ever seen is postal management. They're worse than the inmates that I worked with for 6 years at the jail. They're the most worthless, dishonest human beings I've ever seen other than your president, Brian Renfro. Carriers, we are not sitting on the clock. Any stationary time will be taken back. They're telling you there that they're going to steal from you, okay? Been in my office for 12 years now, and all of a sudden management is telling us you can't have a no lunch unless you help with a swing off another route. Wouldn't this be favoritism? Regardless, I plan on filing a grievance. That's just another thing that just a manager coming in, hey, look, no more no lunches unless you do a swing, okay? We're not going to just give you a no lunch anymore like we had been. You got to do a swing now. So again, just them fucking with us because they can. At a stand-up this morning, we were advised we're not allowed to back up ever. Listen to this shit. If we have to back up, we have to call supervisors. They have to look on the map, and if a backup is necessary, they are to come out to our location and back up for us. This is Colorado, coming down from the Wyoming district. I'm going to read that again. At the stand-up this morning, we were advised we're not allowed to back up ever. If we have to back up, we have to call supervisors. They have to look on the map, and if a backup is necessary, they are to come out to our location and back up for us. That's out of the Wyoming districts, Colorado. This shit is happening. This shit is happening because it's just management wanting to fuck with us. They never stop fucking with us. Now, as soon as they sit in that seat, I'm filing a grievance Article 1. You're doing my work. But if you're not supposed to back up ever, just like arbitrator Miles said in that arbitration I had in Memphis, he stopped the questioning and asked the postmaster, Why is there an R on the gear shift? And the postmaster couldn't answer it. Why is there an R on the gear shift if there's supposed to be no backing ever? Because that's what they said. There'd be no backing ever. He said, why is there an R on the gear shift if there's supposed to be no backing? That's how stupid this is. Had a stand-up this morning. We're advised we're not allowed to back up ever. God. And they're going to come out and do it for us. There's a huge shitstorm happening at our office right now. Long story, as short as possible. Our postmaster just had a mass investigative interview with dozens of carriers today at once. I'm not joking. This is it. That's not me. Not joking. They threatened to fire anyone that calls in going forward, and that sick leave is no longer authorized. Our shop stewards all said they're going to grieve this, but that we all need to take it seriously, and that they don't know if they can stop this. Union also said our PM has a large group of carriers they are already currently filing terminations for. I have so many questions and concerns here. Like, first of all, what the actual fuck are we doing here, people? How are we allowing this to happen? I'm going to read this again. Our PM just had a mass investigative interview with dozens of carriers today at once, not joking. They threatened to fire anyone that calls in going forward, and that sick leave is no longer authorized. We all think about that shit. And that's just a few things that I took off over the last few days of social media. Just a few things. If you're sitting stationary, we're going to steal your time. Okay? You call in sick, we're going to terminate you. Hey, look, the past practice, y'all taking no lunch. Now y'all going to have to do a swing. Okay? Take off to do that. That's who we work for. When I say you don't hate these motherfuckers enough, that's what I'm talking about. And people don't understand what I say. They don't understand that from me. I hate these motherfuckers, man. I hate these motherfuckers for the things that they have done to my people. In the ergonomics episode, remember what I said? I have seen the depths that these motherfuckers will go to hurt my people. And that's what I'm talking about. You're going to beat that, but here's the problem, again, is that we have grievances backlogged for a fucking year. And now you got some dumb fuck coming out there telling people, hey, look, you call in sick, you're going to be fired. You're terminated. So now what do? They're scared to death. You know why? Because their removal, even though they'll win that easily, is going to be probably, 9-10 months. They're going to be out of fucking work, not getting paid. Because of these dumb fucks. And what do you got a dumb shit up there saying in front of everybody? It's not our fault. I'm going to keep on harping on that shit. Y'all can get used to that. Because it's the dumbest fucking thing I've ever heard. It's our fucking grievance procedure. And the motherfucker that's running it saying it's not our fucking fault. I'm telling you motherfuckers, we're in trouble. Shit. Here I go. See, I can't just do an episode where I'm nice anymore. Or I'm nice, polite. If you ever saw me, I'm the nicest guy you'll ever meet. I am. I'm just completely chill. But I see this shit, man. You didn't realize I'm 56 years old. I've been doing this shit for 33 years. Over half my life, I've been light blue. I've been carrying mail. Over half my life. It's in my fucking blood. My blood is not red. If you cut me, the shit's light blue. It's all I fucking know. This is all I know. And you got motherfuckers doing shit to us like this. Where are we fucking at? Here's what I'm going to propose to James Henry when we take over. And I know he'll let me do it. I'm going to say that. But Paul Bolanger's going to educate the dogs of war, okay? About joint, there primarily is initially about joint statement, those vital few. We're going to go after the toxic working environment. Now, that's James Henry and I talking about that, okay? We came up with that about the toxic environment. We sit down all the time. What are the things? What's the list of things we need to have happen? Okay, obviously the backlog of grievances. But to me, the toxic working environment is something and you can see that. You can see that because our Our brothers and sisters are killing themselves. Okay? The toxic working environment is caused, the mental anguish that it's caused, just the dread of coming into a working environment with that. They're killing themselves. Okay? And so we said, what will we do, Dogs of War? We're going to have teams in there that are immune from management's bullshit because they report to us and us alone. And so they're going to go into these stations, right? And they're going to have district managers involved. That way, when I talk about inconveniencing these dumb fucks, you have district managers having to go to arbitration to talk about, cover for those pieces of shit on the workroom floor. You do that enough, they will handle things themselves. That's just the nature of the beast. You inconvenience them enough. Hey, during your day, I know that you've got all these things. You probably got to go to Washington, but we're subpoenaing you to come to arbitration to answer for this postmaster or manager. You know, the one that we emailed you about. So we're going to start subpoenaing those people to come in there and testify. That's Dogs of War, okay, in a nutshell. They're going to be ruthless individuals. Okay, when I said rabbit-ass dogs, that's what I mean. They're ruthless individuals. I had a supervisor when we went to Hattiesburg crying to me, little tears, asking me to not. And I just kept going. You know why? Because I don't consider them to be human. They are subhuman to me. That's how I feel. I hate them, okay? I don't care if you cry. Don't give a fuck. They said that the station manager in Gadsden, when we had her removed, was crying, packing her shit. Good. You need to. And so that's how I am. That's me. Okay. I want other teams, and Paul Bolanger and I have talked about this, other teams, Dogs of War, not just for joint statement things, but falsification of clock rings. I'd like to see that. Experts at that. Okay. 6-day count. Could you do that? Sure. You could do that. How about shit like this? Where a manager says, any stupid ass remark, a manager says, hey, anybody who uses sick leave from here on out is going to be fired. Within a few days, have a team walk into that station. My name's Corey Walton. I'm certified steward here in lieu of the steward on Article 17. Here's an information request. I need to interview all the city letter carriers that were here on this date, okay? And I'm also going to need these things. Here's a relevancy letter. Gotcha. Here's a grievance for the relevancy letter. All right, we're going to address that through the grievance procedure. Still need these interviews, okay? To me, that's a violation of the joint statement. Matter of fact, I got a case for you I'm fixing to read in just a second. That's going to help you out, all right? With that, where an arbitrator said the threat of discipline is a violation of the joint statement. All right. And so have Dogs of War for that, because what I'm not going to have are my people fucked with any longer. I'm not going to fucking have it. I am so sick of this shit, man. And a complacent agent. Fucking complacent as fuck. And so we will continue to educate here. You got a lot of podcasts coming out educating, which is fantastic. A lot on social media educating. Do you know why that's happening? Do y'all know why? It's the city letter carrier standing up to protect the city letter carrier. That's all this is from aid arbitration. This isn't to help National. The motherfuckers blackballed me. It's not to help my fucking business agent. That cowardly motherfucker, he blackballed me. It's not to help those motherfuckers. It's to help the city letter carrier like Blue. And they don't understand that. They don't get it. They don't understand why I'd spend $30 a month to educate the city letter carrier. Do you know why? Because I love the city letter carrier. If you have that unbridled passion, that love affair for the city letter carrier that we talked about all these episodes ago, if you've got that love affair for the city letter carrier, you would understand what we're talking about. You would understand, all this would make perfect sense. All of it. All the time. Prepping, preparing, going, meeting, the leave without pay. It would all make sense to you if you had that passionate love affair for the city letter carrier. It would all make sense. That's the reason people get on social media and they help other carriers. It's not for themselves, not to say, hey, look here what I did. That's not for that. It's to help their brothers and sisters that are in need. These other podcasts that have come out educating their brothers and sisters. It's not to say, hey, look here who I am. It's not to sell a shirt. It's because you love the fucking city letter carrier. And the agent has no idea what that's about. And that's tragic. It's tragic. But like I said, I've been saying, we're taking back over this motherfucker next year, and the city letter carrier is going to be put back in charge of this thing. Okay? And that way, when you have things like this come out on social media, or you reach out to Paul Bolanger and you say, hey, in my station, this has happened. I've got a trigger, okay? I've now got a trigger, a date, a happening, and I can send a team in. And that's what we'll do. We'll call the 2 or 3, probably 3. I imagine the teams will be made up of 3. That's what ours was. We'll call the 3 and say, hey, get your plane ticket. You're going here. Plan on being there a week. This is the situation. We've looked up this manager. We have a database on cease and desist or shall comply, whatever bullshit. And we're going to be sending that to y'all so that y'all have that ready for the file. And then so-and-so out of the 3, you're going to be the informal A. You're going to be the steward on record, okay? So-and-so, you're going to be the formal A for this grievance. So-and-so, you're probably going to be the advocate, or you can stay back and write the contentions while we're gathering information. And one of these 3 will be an experienced advocate. You're going to take the case forward. And so you 3 are going to see it from beginning to end, from alpha to omega. You're going to be the beginning and the end of it, okay? And so that's what's going to happen. And so, yeah, we'll have it for different things. But I'm not playing. I'm not fucking around. I am not fucking around. This shit right here pisses me off. Pisses me off that you would have somebody saying, hey, look here on this, they're telling us that we can't call in sick or all of us be terminated. All right. Let's see if I've got anything else. Let's get into these grievances. Y'all want to get into some grievances? Let's do it. First thing I want to go over is the management's requiring us to get updated medical every 30 days. This is going to be very simple, but it's not. The grievance would be simple, but it's not simple to us. Why? Because here's the issue that I have with us, all right? And you see a lot more people with medical documentation now than I never heard of it when I started. My first 20 years here, I didn't hear of medical documentation for 8-hour restriction. That just wasn't very common. Now it's everywhere. And some people say, well, it's just carriers trying to get over. I don't buy into that at all. I don't buy into that shit at all. It's just people not wanting to be forced work. Don't buy into that shit at all. At all. I don't buy into it. Here's why. Right now, more than any time in the history of us, we have a toxic working environment. Okay? I think everybody could agree to that. That's the reason James Henry said that's priority 1 to him. If it's priority 1 to him, it's priority 1 to me, and it's going to be priority 1 to Paul Bolanger. That's just how it's going to be. The toxic working environment is priority 1. Why? Because it causes more mental anguish, stress, all these things to us, the city letter carrier, which we carry home to our spouses, our loved ones, and our children, okay? I'm going to read this out of publication 552. Now, it's probably been updated since then, but it says cost and effects of harassment. Costs and effects of harassment. I want y'all to listen to these stats. Harassment, including harassing behavior that may not be illegal under federal law, undermines morale in the workplace. It undermines the morale of the individual being targeted, persons witnessing the harassment, and persons who hear about the harassment from the target and witnesses. Workplace harassment can affect a person's emotional and physical well-being, reputation, and physical safety. Targets of workplace harassment may experience stress, depression, low self-esteem, loss of sleep, and even post-traumatic stress disorder. Harassment can also impact the home environment of those affected at work. Now, that was lengthy. I'm going to read this again. This is out of publication 552, and if that sounds familiar, it's because it's out of the Postal Service policy on workplace harassment. When we talk about down at the bottom of the first page where it says management's responsibilities, it says they must initiate an IMIP. Okay, and an IMIP is found where? In publication 552. All right, so this is publication 552, and it's titled Management's Guide to Understanding, Investigating, and Preventing Harassment. Okay, it does not say the union's guide. It does not say the party's guide to understanding. It says manager's guide to understanding, investigating, and preventing harassment. So this is from management to managers, okay? Costs and effects of harassment. Now, this is why when people talk about 8-hour restrictions, 40-hour restrictions, whatever, and they want to come up with some lame-ass excuse that people don't want to work, no, it's not. This is why, to me, and there's a few other reasons I'll talk about in just a second. Harassment, including harassing behavior that may not be illegal under federal law, undermines morale in the workplace. It undermines the morale of the individual being targeted, persons witnessing the harassment, and persons who hear about the harassment from the target and witnesses. Workplace harassment can affect a person's emotional and physical well-being, reputation, and physical safety. Targets of workplace harassment may experience stress, depression, low self-esteem, loss of sleep, and even post-traumatic stress disorder. Harassment can also impact the home environment of those affected at work. These effects on individual employees also have a negative effect on productivity, product quality, job satisfaction, attendance, and employee retention in the workplace. The cost of illegal harassment can also include attorney's fees, settlements, and court costs. Harassment can also affect workers' compensation costs. Research indicates that 1/3 to 1/2 of all stress-related illnesses is attributable to bullying in the workplace. Even basic incivility has an effect on the workplace. For example, one study shows the following responses of 775 people who were targets of incivility at work. Incivility included rudeness, insensitivity, and disrespect inflicted by another worker, the instigator. Percentage affected, 28% lost work time avoiding the instigator. 53% lost work time worrying about the incident or future interactions. 37% believed that their commitment to the organization declined. 22% decreased their effort at work. 10% decreased the amount of time that they spent at work. 46% contemplated changing jobs to avoid the instigator. 12% actually changed jobs to avoid the instigator. Harassing behavior is unprofessional. Postal Service managers, postmasters, and supervisors are responsible for setting the parameters of appropriate behavior at work and for addressing inappropriate behavior by their employees. Successful managers, postmasters, and supervisors do not harass, bully, or speak to employees in a condescending or threatening manner. Now let me ask you that. Did that person, that postmaster who said anybody else who calls in sick from here on out will be terminated? No more sick leave. You'll be terminated. Do you think that they went along with this right here? Are they in compliance with this right here? That would be a question I'm going to ask them in arbitration when I take their funky ass in there about what they said. I'm going to read this to you, sir. And I'm going to read it, and then I'm going to say, sir, do you feel like what you said was in compliance with this when it talks about Manager's Guide to Understanding, Investigating, and Preventing Harassment? Do you feel like you were complying with that right there when you said you will all be fired if you call in sick? And we'll get that on the record. Successful managers, postmasters, and supervisors lead by example. They stop and correct harassing and inappropriate behavior by their employees. Never take harassment allegations lightly. The cost of harassment to our employees and our bottom line are costs the Postal Service cannot afford. I wanted to read that to y'all. Next time somebody says you got 8-hour restrictions because you just don't want to work. You get 8-hour restrictions now because why? We're understaffed. And you fucked us over in the TA that could have helped us with that. We're understaffed. We're underpaid. You got a toxic working environment, right? Probably mandating. I'm not on the list, but you're mandating me every single day. Why? Because you're understaffed. Why? Because you got a toxic manager that's running all the new hires off, right? Why? Because you have nobody coming to the carrier's defense on either side to rid the company. Management's never going to do it. They're never going to take that into account when they do anything. They're never going to take unruly managers out of the workforce. They're just not going to do it. They're not going to correct their own. You got, just an example, 45-minute office time. Do you think that's going to help with the toxic working environment? Do you think that's going to help us want to come in? You got a 5-minute PM office time. So that's 50 minutes total office time they've given you. They've taken it out of 60. We had 60 at least. With the metric, 60. You know, you have these things where your own president talked about inconvenient stationary events. You heard that and them say, hey, any stationary time, we're going to deduct that from your check. We're going to deduct any stationary time, okay? If we see that you're stationary, just know that time's being deleted. And your president said that was an inconvenience to you. Got stationary events, stuff like that. All these things attributing to a toxic working environment. And nothing being done. So we get a doctor's note. It says you get PTSD and stuff like that. I just read that. You get a doctor's note, right? And the doctor says, hey, Corey cannot work for more than 8 hours a day, 40 hours a week. And so the instigator, the bully, what do they say? We're not going to accept it. You need to go back and get that every 30 days, okay? And if you don't, we're going to terminate you. That's happening. They're getting disciplined at this place where this person reached out. We're going to terminate you. We're going to discipline you for not going back and getting medical documentation every 30 days. That's what we're going to do. Okay? I got a couple of things for you. Here's what we're going to do. Now, here's your grievance. M1360. Get your pen and paper. I'll give you a second. Get your pen and paper. Got a couple of these, and I got some sites I'm going to help you with, okay? M1360. Dear Mr. Sombrado, this is back from 98, and these things are still just as relevant, okay? I don't care if these things said 08. If it's an M document, step 4, they're still good. On August 14, 1998, I met with your representative to discuss the above captioned grievance, currently at the 4th step of our contractual grievance procedure. After reviewing this matter, we mutually agreed that no national interpretive issue is fairly presented in this case, with the following understanding from the Snow Award and case number, and get this note, because the Snow Award is good, okay? An inability to work overtime does not necessarily prohibit an employee from performing his or her normal assignment. Accordingly, such an individual working with such a restriction is not necessarily on light duty. Employees restricted from working overtime may bid on and receive assignments for which they can perform a regular 8-hour assignment. Now, I'm going to have 3 of these, okay? All 3 of these will go in your case file. Accordingly, we agreed to remand this case to the parties at Step 3 for further processing to be scheduled for arbitration as appropriate. I'm going to read this again. An inability to work overtime, that's over 8 hours, okay? Because we're a union. Anything over 8 is overtime. An inability to work overtime does not necessarily prohibit an employee from performing his or her normal assignment. Accordingly, such an individual working with such a restriction is not necessarily on light duty. So if they try to give us some kind of light duty job offer, this will help you there because they hate us, right? And anytime we come in with some kind of restriction, what do? Try to bludgeon us for it. Employees restricted from working overtime may bid on and receive assignments for which they can perform a regular 8-hour assignment. That's M1360. That's going to go in your case file. Here's another one. M1437. This is the biggest one. M1437. Now, when somebody put this out on social media the other day, everybody was putting this on there, which is a beautiful thing. It's a beautiful thing. Matter of fact, I think it was on my page for Made Arbitration. They said, hey, Corey couldn't find his shit. Here's this. Fantastic work. That's how you do things, city letter carriers, taking care of each other. Said, hey, Corey couldn't find his shit, and so here's this. And this is it, okay? M1437. Dear Mr. Young, recently our representatives met in pre-arbitration discussions of the above referenced grievance. The issue in this grievance is whether a local blanket policy requiring an update of medical information every 30 days to continue in a light-duty assignment is a violation of Article 13 of the National Agreement. After reviewing this matter, we mutually agree that while no national interpretive issue is fairly presented in this case, the issue is resolved as follows. The parties agree that the local practice of requiring an automatic update of medical information every 30 days is contrary to the intent of Article 13 and therefore will be discontinued. I'll read that again. The parties agree that the local practice of requiring an automatic update of medical information every 30 days is contrary to the intent of Article 13 and therefore will be discontinued. That would be my first contention. All right? M1437. M1437. Consistent with the provisions of Article 13.4F of the National Agreement, an installation head may request an employee on light duty to submit to a medical review at any time. The installation head shall review each light duty reassignment at least once each year, or at any time the installation head has reason to believe the incumbent is able to perform satisfactory and other than the light duty assignment the employee occupies. This review is to determine the need for continuation of the employee in the light duty assignment. Such employee may be requested to submit to a medical review by a physician designated by the installation head if the installation head believes such examination to be necessary. So you've got that one, and you got the one I just read to you about if you can't work over 8 doesn't mean that you're light duty. Okay, so those two are great ones. And here's the last one, M1807. M1807. This one's hard to read. Even when you get it, it's going to be hard to read. When craft employers provide medical documentation indicating that they have a disability and cannot work more than 8 hours, or that they required other accommodations that may impact their ability to deliver the mail in an efficient manner, this can be challenging for a manager with limited resources who is trying to move the mail. However, the answer is neither to work disabled employees outside of their restrictions, nor to discipline them for being unable to complete their route. Significant liability may result from those courses of action. A decision was recently issued against the Postal Service in an Equal Employment Opportunity Commission EEOC case based upon a finding of disability discrimination and retaliation. The EEOC administrative judge awarded the employee a letter carrier $200,000 in compensatory damage, 39 days of back pay, $12,420 for psychological treatment, and $118,659 in attorney fees, expert witnesses fees, and costs. This case is significant because it highlights a growing trend in USPS EEOC complaints, allegations that managers are disregarding employees' medical restrictions. In this particular case, the judge found that management was on notice of the carrier's restrictions by virtue of medical documentation she had submitted to management, as well as her statements regarding those restrictions. The carrier's primary restrictions were a limitation that she could work no more than 8 hours per day and a requirement that she be granted a 10-minute stretch break every hour. The judge determined that the carrier was frequently required to work more than 8 hours and that her workload was not adjusted to allow for the 10-minute breaks. There was also a finding that the carrier was harassed when she attempted to abide by her medical restrictions. M1807. Have that one in your file. Okay? Those are 3 beautiful ones right there. 3 beautiful ones. And that's what we're going to do. In the letter, I've got the letter. This is what it states. Mr. So-and-so, records reveal you have submitted documentation stating you have a medical condition that prevents you from completing your route completely or limits the number of hours you can work in a day week. You're required to provide updated medical documentation notifying me of your work status every 30 days. You have not kept me updated on your status, so that's already a violation of the things that we just read. As an employee, you have the responsibility to report for a duty as scheduled in accordance with 513.36 of the Employee and Labor Relations Manual. Now, they're misquoting that. 513.36. They're misquoting that, okay? Attached, employees on leave for extended periods are required to submit satisfactory evidence of continued incapacity for work. Records reveal that you have failed to satisfy this requirement. I'm not on extended leave. I'm working every day. I'm not on extended leave. That means if I'm disabled, I cannot come in for an extended period of time. Once I come back, then 513.36 takes effect. I'm working every day. This doesn't apply for me. I'm not on an extended leave for an extended period of time. You see me every day. I just can't work more than 8 hours. Immediately upon request of this letter, you're instructed to provide current medical documentation stating what your current restrictions are and when they're expected to end. You're also directed to provide me by October 20th with acceptable documentation to substantiate you from duty. You're also directed to provide me with satisfactory evidence of your continued restrictions for work every 30 days after October 30th. So this is a standing 30 day. Failure to contact me immediately and provide acceptable documentation to me by October 20th and every 30 days thereafter will result in a failure to follow instructions and restrictions not being accommodated. Pursuant to the Employees and Labor Relations Manual, if you request sick leave, your absence of more than 3 days must be substantiated by medical documentation of your total incapacitation for duty. And so they're threatening them with failure to follow instructions. They've given them discipline, right? I've got something for you. I've got 3 sites. 3 sites, and you can put these in your file as well. The first one is Arbitrator Lumley, and the guy that did it for us was Tom Ken. It's 35941. C35941. And the language that he uses, that he talks about in here, if you're going to recognize it. Position of the union. The union's sole claim is the case is that the employer improperly based its request on April 29th on the ELM sections 513.332 and 513.364. That's the one that was in that letter, okay? So this is going to help you out. Decision of the arbitrator. Having now had the opportunity to consider the entire record in this matter, I have decided that management's request grounded in ELM Section 513 for additional medical information for the grievant was improper and thereby violated Article 19 of the National Agreement. While I have studied all the evidence submitted and considered each argument raised, the following discussion will address only those considerations I found either controlling or necessary to make my decision clear. The question presented in this dispute is a very narrow one, namely, whether management could base its request to the agreement on ELM Section 513, the defense offered up by management at formal Step A. I agree with the union that management was not privileged to do so since ELM Section 513 addresses the sole issue of sick leave, a matter not involved here. The relevant physician's request was not the agreement being granted sick leave, but only that he not work more than 8 hours per day. Nor can management's Article 3 retained rights be read as rewriting the clear language of the M. As a result, management's reliance on the M, Section 513, violated Article 19 of the National Agreement, and I shall grant the union's requested remedy of a cease and desist order. It is awarded the arbitrator that management's request grounded in Elm Section 513 for additional medical information from the agreement was improper and thereby violated Article 19 of the National Agreement. Therefore, ordered management cease and desist based request for additional medical information from the agreement on Elm Section 513, and they retain jurisdiction. So, I read that again. The relevant physician's request was not the agreement being granted sick leave, but only that he not work more than 8 hours per day. And that's what we're talking about. Them citing 513 is not for this. It's not for my 8-hour restriction. That's if I've been out for an extended period of time. Okay? That's C35941. 35941. Here's one that you'll use when you're having to go until we can get this shit resolved, going to the doctor when they told you to do so. It's C33148. 33148, and it's Paul Chapdelaine. And for us is Ron Neal. Paul Chapdelaine. And it's going to be very brief. And I'm not going to read the decision. Here's the award. The grievance is sustained as a remedy. The service is directed to compensate the agreement in the amount of $25 to cover the amount of the insurance co-payment paid by the agreement in order to obtain the medical documentation he was arbitrarily directed to provide. So when you have a grievance that we're going to file where you have arbitrarily made me go get medical documentation, again, because I've already given it to you, you come out with this blanket policy that every 30 days I'm going to get medical documentation. And so I'm going to file this grievance, but you're issuing me discipline. So I'm probably going to go. When I go, I'm going to have a copay. We're going to make management pay us back for that copay. And that's what this one is. 33148. 33148. And the issue be deciding this arbitration is whether management violated Articles 10 and 19 of the National Agreement when requiring the agreement to provide medical documentation for an absence of less than 3 days, which obviously is a violation because we don't have to do so. But this will also help you in this same instance, okay? It'll help you in the same instance. 33148. And here's another one that I liked a lot. For individuals like this clown telling y'all that anybody that calls in sick will be removed. Okay? You're going to be terminated if you call in sick from here on out. Or this case, where they've already issued discipline because you didn't provide medical documentation. I want you to listen to this language. Now, this is Arbitrator Samarco. Arbitrator Samarco, 37238. 37238. Now, they issued this person some suspensions and stuff. After the investigational interview, grievant provided the summary of visit dated 7/3, 5/28, and 7/11. She was told by the owner that the documents were not sufficient. She did not explain to the grievant why they were not sufficient. She testified that she not remember but thinks she might have talked to the nurses between the interview on 7/16 and the date of the letter of warning. The allegations herein are that management's issuance of the 2 letters and the letter of warning juxtaposed to the prior letter of warning and 7-day suspension constituted harassment and thus a stressful and unhelpful situation. This arbitrator agrees that the closeness in time of these actions and the implied intent of management to essentially ignore Mr. Farless's request for clarification and the continued threats of the grievance livelihood via termination constitutes a violation of the JSOV. I'll read that last part again. This arbitrator agrees that the closeness in time of these actions and the implied intent of management to essentially ignore Mr. Farless's request for clarification and continued threats of the grievance livelihood via termination constitutes a violation of the JSOV. Therefore, the grievance is sustained. So, when you have a clown get up on the workroom floor and say, hey, y'all call in sick from here on out, you're all going to be terminated. Here's your site. When you have management saying, hey, We're going to implement a policy inconsistent with the ELM. And we're going to require documentation every 30 days. Even though we have things now that we've just read where they can't do that. Anytime we have that happen, they're going to say, hey, if you don't bring me the documentation, I'm going to revoke your doctor's restrictions. I'm going to cancel those. And I'm going to start disciplining you. I'm going to put in my issue as well, Article 15 and 19, the JSOV. All right? And Samarco 37238. That's a good site for you. All right, lastly, this is that I was talking about the other day. And I love this. It just because you don't think about it really. You don't think about it really, but this individual sent me this about the counterfeit labels. Because we need our money, right? We need our money. And so it says, can I pay for postage to retrieve intercepted or seized items? Why can USPS treat packages with counterfeit or unpaid postage as abandoned or postal property when I purchase goods and pay for their delivery? We understand that consumers purchase goods online and after making payment expect to receive a delivery. Even if the consumer was charged for postage, the mailing was arranged by or on behalf of the vendor sender, not the consumer. Therefore, consumers may find that the goods they ordered were mailed with counterfeit postage. In other cases, there could be a delay in payment of postage by the vendor sender. Multiple checks can occur and may delay delivery of the mailing until USPS receives that payment. Postal regulations only allow delivery when postage has been prepaid by the sender. Senders that affix counterfeit postage on parcels have not paid for the delivery and typically use invalid return addresses. This makes it impossible for the Postal Service to recover payment from the sender. Packages seized by the USPS for counterfeit postage or unpaid postage has been removed from the mail stream, will not be delivered to the recipient, will not be returned to the sender. Y'all hearing me? Has been removed from the mail stream, will not be delivered to the recipient, and will not be returned to sender. And here's your grievance, very brief. That's Article 19. Domestic Mail Manual. Article 19 via the Domestic Mail Manual. Section 8.4, Counterfeit Postage. 8.4.1, Definition. Counterfeit postage is any marking or indicia that has been made, printed, or otherwise created without authorization from the Postal Service, that is printed, applied, or otherwise affixed on an article placed in the mail that indicates or represents that valid postage has been paid to mail the article. 8.4.2, Handling items with counterfeit postage. Items found in the mail bearing counterfeit postage will be considered abandoned and will be disposed of at the discretion of the Postal Service. So that was what I was reading earlier. You're not going to send it back, and you're not going to deliver it. Items found in the mail bearing counterfeit postage will be considered abandoned and will be disposed of at the discretion of the Postal Service. I'm going to read the first part again. Counterfeit postage, 8.4.1, definition. Counterfeit postage is any marking or indicia that has been made, printed, or otherwise created without authorization from the Postal Service. That is printed, applied, or otherwise affixed on an article placed in the mail that indicates or represents that valid postage has been paid to mail the article. Now, the only time this grievance is going to come into effect is if you take it up to management and they make you deliver it. We're going to grieve it, all right? Because we're not being paid for it, and we need all of our money. So if you take a counterfeit package up to management, you say, hey, this has counterfeit postage on it, and they say, deliver it anyway, there's your grievance. Article 19, via Section 8.4 of the Domestic Mail Manual. It's that simple. It's that, and I loved it. When the guy sent it to me, I said, fuck, I never thought of that. It's a damn good one. It's a damn good one. It'll start making these people put proper posters on it. Because how many millions you think get through us a day? We deliver billions. How many millions you think get through? Article 19 via Section 8.4 of the Domestic Mail Manual. And there you have it. Told you that was going to be brief, but I loved it. When dude sent it to me, I should have screenshotted it, but I didn't. And then I fucking lost it. But so there's your episode. Hell, it's an hour and 20. I didn't want to go there. I thought it'd go about 30 minutes. Because I'm like, those things will be brief. They're very effective, very good. They'll be brief. Hour and 20 minutes. I cuss too much. That's my problem. I cuss too much. It drags shit on. I can't fucking help it. I get pissed off all the fucking time. And I cuss a lot. All the time I come in here and say, hey, look, you cussed last week. Don't fucking cuss today. And you fucking cuss all the fucking time. And so, what do you do? What do you do? Next week, failure to allow an interview with a supervisor. Disciplines for failure to meet standard. And personal items that are case. That sounds good, right? I won't cuss next week. Probably. All right? Hey, I love you, Light Blue. We're going to make it. We're going to make it. Everything's going to be all right. Everything's going to be all right. I promise you. Help is coming. Help is coming. Okay? We've got incompetence on a biblical scale right now. It'll be voted out next year. You've got a president already conceding shit. Just fight. Just shut your mouth and fight. Okay? That's all I want. Just shut your mouth. Don't talk to him anymore. Shut your fucking mouth. Go fight. That's it. I don't want to hear woe is me. Not going to get anything. He's already, the likelihood of us getting something good, not good. I don't want to hear that shit. I don't hear it. Go fight. I know you want to talk. Don't talk. Shut up. Go fight. That's it. That's all. Shut your mouth. Fight. That needs to be his shirt. Instead of fight like hell, it needs to be shut your mouth. Go fight. Let's make some shirts with that. Shut your mouth. Go fight. That's a good one. Right? Shut your mouth and go fight. I like that. Just came up with that. That's pretty good. But he's losing. We'll lose. Gonna lose. He's done. He's doing all he can. He's everywhere. God, I've never seen a motherfucker. I've not seen him in 3 years. I've not seen the motherfucker in 3 years. I mean, he's everywhere right now. Open up the toilet, there's a motherfucker looking at me. I'm like, what motherfucker? How you get in there? You know, you take a shower, you wipe off the window from the glass from the fog, motherfucker's right there. Motherfucker. That's just like a nightmare. He's every fucking where. Open up the medical cabinet, motherfucker's face is right there. He's like all these old horror movies that you see. Look under the bed, here's that motherfucker's face. So, I can't. Hell, I hated seeing a motherfucker before, but damn, he's all over the place now. But he's already conceding. Joe Galanka, I don't know if y'all know him. He's the godfather. The smartest dude I know in the union is a guy named Joe Galanka. Dude is absolutely fucking brilliant. Absolutely brilliant. He knows more. He's forgotten more than I will ever know. That's how smart this guy is. He's one of those that when somebody asks a question, you see Joe Galanka's answered it, you just keep going because there's nothing you can add to it. But they put that clip of Renfro conceding already. And people coming to his defense, I'm like, well, hell, you know, what do you want him to do? He's just being honest with you. Here's what Joe said, and I thought it was absolutely fucking beautiful. On the other hand, if your stated negotiating position is that you must give up something to get something back in order to gain something, as has been repeatedly expressed by Renfro and his sycophants, then you've already lost before negotiations ever begin. Or again, on the other hand, if your stated negotiating position is that you must give up something or give something back in order to gain something, as has been repeatedly expressed by Renfro and his sycophants, you've already lost before negotiations ever begin. And somebody else, I need to read this. I forgot. I need to read this before I get out here. But the CLC put up this thing for the Fighting NELC, Build a Fighting NELC, they're doing that survey. So they put it up, and somebody, I guess, thought that we did it, that the CLC did it. And he's like, oh, that sounds good, but, what are you going to give up? What are you going to concede to get these things? What are you going to give back to give these things? And that's what Joe was talking about. If that's your position, is to get stuff, you have to give up stuff, we've already lost. You've already lost it. You have demands. These are the things that we want. Okay? All career workforce. That's something that's very important to me. Obviously, the wages have got to be definitely better. Everybody would agree with that. The table 1s, 2s, those things like that, all those things are priority for us. Okay? So when you go into negotiations, you say, these are the things that we've talked it over with our people. You must have. You must have. We're not going to give things to get things. These are the things that we need. If you're not going to give them, we're going to arbitration. That's my position. These are musts. Like Renfro said, all career workforce is a non-starter. Right? CCAs. We're going to do away with the CCA workforce. CCA is going to come in with a substantial starting wage. 9%. Settle for nothing less than 9%. It's like, but those are the things that they're musts. Okay, they're non-negotiable. We're not negotiating those things. These are the things that we must have. If they say no, then we're going to arbitration. It's really that simple. He can talk for 10 hours about the different ways to negotiate and all the different things that go into play and all that shit. These are musts. These are things that we must have. It's that simple. Here's Build a Fighting NELC. And get on there, if you go to their Facebook page, you can do this survey. They needed 2,000 signatures. They've already got well over 1,000. Okay? Make your voice heard. As a unionized workforce, our strength comes from our members. To build power, union members must actively participate in determining the union's demands and issues. Our union contract is the most important document in our working lives. It establishes our wages, benefits, and working conditions. Build a Fighting NELC is a bottom-up, rank-and-file driven reform movement inside the NELC that has fought for and won open bargaining and contract rallies at the 2024 NELC convention, committed to reforming the NELC from the bottom up, and to do so, we must listen to and acknowledge the voices of the rank and file. Please take a few minutes to fill out this survey to help us gather a grassroots list of contract demands to make voices heard. And so that's the BFN. If you get on buildafightingnelc.com or Build a Fighting NELC, the Facebook page, those things will be on there, the survey. Fill it out, okay? They wanted 2,000. They've already got well over 1,000. So get on there, make your voices heard. I put it up on From A to Arbitration, my Facebook page the other day. Get on that if you're a member of that, and fill it out. Okay, that's the best way to do it. Fill it out. He has these committees come up there. This is a committee of 2,000. All right, they're going to tell you what they want, and look at them. Some of them may not be achievable, but they're going. It's our concerns, right? It's our concerns. So. There you have it for this week. Make sure you pay attention next week. We're going to have some good ones. Got some good sites for you, all right? I love you, Light Blue. You know that. I love you. I can't wait to get in there and start kicking ass for you, all right? We cannot wait to get in there. We can't. I love you. Y'all have a great week. It's going to be cold tomorrow. Make sure you got your long johns on while you're out there delivering, okay? Don't need any cold peeps out there. I love you. I'll talk to you later. Bye.